The strange thing about owning something worth millions of dollars is that the hardest part sometimes isn't proving it belongs to you. It's convincing everyone else to stop pretending it belongs to them. That was the only thought running through my mind as I stood on a rocky overlook watching sheriff's deputies, county officials, and survey crews slowly make their way down the winding road into the valley below. Nearly 200 homes stretched across the landscape, surrounded by carefully maintained streets, decorative entrance signs, manicured parks, and a clubhouse with a massive stone arch proudly displaying the name Silver Ridge Estates. Standing beside that sign, wearing a bright designer blazer covered in bold colors, oversized sunglasses, and enough jewelry to catch the morning sunlight from 50 yards away, was Victoria Langford. She folded her arms with complete confidence, smiling as though the people arriving worked for her instead of the county. She had absolutely no idea that the paperwork sitting inside the leather folder under my arm had already changed everything. 3 weeks earlier, I didn't even know this valley existed. My name is Caleb Mercer, and until a certified envelope appeared in my mailbox on an ordinary Tuesday afternoon, I believed my life was about as predictable as anyone could hope for. I worked as a commercial land consultant outside Missoula, Montana, spending most of my days reviewing property records, evaluating ranches, and helping buyers avoid expensive mistakes. My career had taught me one lesson that never failed. Land remembers the truth, even when people don't. Fences move, roads change, buildings appear and disappear. But ownership always leaves a paper trail somewhere if you're willing to look long enough. That's probably why the attorney handling my late great-uncle's estate contacted me instead of another distant relative. According to the family records, Uncle Walter Mercer had lived alone for decades and rarely spoke to anyone outside a small circle of old friends. I remembered meeting him only twice as a child, both times at family reunions where he spent more time talking about mountain streams and timber than people. When I arrived at the attorney's office, I expected to sign paperwork for an old pickup truck or perhaps a small cabin somewhere in western Montana. Instead, the attorney slid a thick folder across the conference table and quietly informed me that Walter had left me approximately 2,500 acres of privately owned mountain valley. I honestly thought there had been a mistake. 2,500 acres sounded less like an inheritance and more like something owned by a corporation or a state park. The attorney smiled politely because, apparently, I wasn't the first person to react that way. He explained that the property had remained in the Mercer family for nearly 80 years, passing quietly from one generation to another without ever being divided or sold. Walter had continued paying the property taxes every year through a family trust. Everything appeared current, legally recorded, and remarkably well documented. There was only one unusual note attached to the file. During the past decade, Walter had become physically unable to travel regularly to the property due to declining health. The attorney admitted no one involved with the estate had personally inspected the land in years. I didn't think much about that detail at first. Large rural properties often sat untouched for months or even years at a time. 2 days later, I loaded my truck, drove several hours into the mountains, and followed an old county highway that eventually narrowed into a scenic road winding through dense pine forests. The GPS matched the survey maps perfectly until I rounded one final bend and suddenly found myself staring at something that simply shouldn't have existed. Instead of untouched valley land, there was a professionally landscaped entrance featuring stone columns, flower beds, decorative lighting, and a large wooden sign welcoming residents to Silver Ridge Estates. Beyond the entrance stretched paved streets lined with upscale homes, neatly trimmed lawns, community mailboxes, and families walking dogs as though the neighborhood had existed forever. For several seconds, I genuinely questioned whether I had taken the wrong road. I pulled over, compared my survey map against the GPS coordinates 3 different times, and felt my stomach tighten with every confirmation. I was exactly where I was supposed to be. The valley was mine. The neighborhood wasn't supposed to be there. Before I could even process what I was looking at, a luxury SUV rolled slowly toward me and stopped beside the shoulder. The driver's door opened, and a heavy-set woman stepped out with effortless confidence, adjusting the sleeve of her colorful designer blazer before offering the kind of smile that never quite reached her eyes. "Good afternoon," she said. "I'm Victoria Langford, president of the Silver Ridge Homeowners Association. Can I ask why you're parked on private community property?" Victoria stood with the relaxed confidence of someone who had repeated the same introduction hundreds of times and never expected anyone to question it. Her colorful designer blazer contrasted sharply with the quiet mountain backdrop, while oversized jewelry shimmered every time she adjusted the leather folder tucked beneath one arm. Behind her, a pair of golf carts rolled past carrying residents who waved as though this was the most ordinary neighborhood in Montana. She smiled politely and waited for my answer. I returned the smile, reached into my truck, and removed the survey map I had printed before leaving the attorney's office. Actually, I said, keeping my voice calm, I believe this property belongs to me. She laughed softly, not because she found the situation amusing, but because she genuinely believed I had misunderstood where I was standing. I am afraid someone gave you incorrect directions, she replied. Silver Ridge Estates is private property managed by the Homeowners Association. Residents own their individual lots, and the association maintains all common areas. We have been operating here for years. I unfolded the map across the hood of my truck and pointed toward the surrounding ridges. Every boundary matched the terrain perfectly. The creek running through the center of the valley appeared exactly where the old survey indicated. Even the distinctive rock formations lining the western slope were identical to photographs stored with the estate records. Only one detail did not belong: the neighborhood itself. These legal descriptions placed this entire valley inside the Mercer family property, I explained. Victoria barely glanced at the documents before folding her arms again. Those papers may refer to something nearby, but they certainly do not describe this community. Her confidence never wavered. It was the confidence of someone who had repeated the same explanation for so long that it had become reality in her own mind. Before I could respond, another resident approached, walking a golden retriever along the sidewalk. He greeted Victoria by name, nodded politely toward me, and continued without asking any questions. Everything about the neighborhood appeared settled, organized, and permanent. Children rode bicycles along freshly paved streets. Landscaping crews trimmed decorative shrubs outside the clubhouse. Delivery vans entered through the front gate without hesitation. Nothing suggested confusion or uncertainty. If I had arrived without the estate records, I would have assumed the community had every legal right to exist exactly where it stood. Victoria eventually glanced toward the security office beside the entrance. Our management company keeps complete records for the association, she said. If you believe there has been some misunderstanding, I would be happy to provide contact information. I accepted the business card she offered, thanked her for her time, and decided not to argue further. Years spent working with land disputes had taught me that emotions rarely solved ownership questions. Documentation did. As I drove away, I noticed something that stayed with me the entire trip back to town. The entrance monument displayed the community name proudly, but nowhere did it identify the original property owner or reference any recorded subdivision number. Most developments included those details somewhere on public filings or official signage. This one did not. That evening, I checked into a small motel about 30 miles away and spread every document across the desk. The estate file contained decades of tax receipts, trust records, aerial photographs, and certified surveys dating back almost 80 years. Every property tax payment had been accepted by the county under the Mercer family name without interruption. There was no indication that the land had ever been sold, divided, or transferred into another ownership structure. I logged into the county property database, expecting to find updated parcel maps reflecting the neighborhood. Instead, the public records still showed one continuous tract owned by the Mercer Family Trust until its recent transfer into my name. I refreshed the page twice because I assumed the system had failed to load recent updates. Nothing changed. Curious now, I searched for Silver Ridge Estates directly. The results surprised me even more. The community appeared in business registrations connected to the Homeowners Association, utility service agreements, landscaping contracts, and promotional real estate materials. Yet I could not immediately locate a recorded subdivision creating the individual residential lots. That absence did not automatically prove anything, but it raised questions I could not ignore. The next morning, I drove to the county recorder's office, hoping the missing pieces would be easy to explain. Public Records Clerk Denise Holloway greeted me with the practiced efficiency of someone who spent every day helping people untangle complicated property histories. When I handed her the parcel number, she typed quietly for several moments before her expression shifted from routine concentration to visible curiosity. She looked back at the screen, then at the survey map resting on the counter, and finally back at me. "This is unusual," she admitted. "Very unusual." Denise rotated her monitor slightly, so I could see the county parcel map displayed across the screen. The thick boundary line outlining the valley matched every survey I had brought with me, stretching across approximately 2,500 acres without a single subdivision line cutting through it. She zoomed in several times, expecting additional layers to appear, but the map remained exactly the same. "According to the official property records," she said carefully, "this entire tract transferred from the Mercer family trust into your name through the estate filing that was recorded last week." I asked the question that had been forming in my mind since I first drove through the entrance monument. "Then how can an entire neighborhood be sitting on it?" Denise leaned back in her chair and gave a small shrug. "That is the part one cannot answer from this office. We record documents that are filed with the county. We do not create them." She searched another database containing decades of archived filings, beginning with the oldest records available and working forward year by year. Easements appeared for electrical service. Utility agreements appeared for water infrastructure. Road maintenance permits had been issued at various times. There were environmental reports, construction inspections, and contractor registrations. Everything suggested that the community had gradually expanded over many years. Yet one document continued to be missing. There was no recorded subdivision creating individual residential parcels from the original Mercer property. Denise eventually printed several certified copies of the ownership history and highlighted the uninterrupted chain of title. "If another office has documents that never reached us, an attorney might be able to locate them," she explained. "But based on what I can see here today, the ownership history has never left your family." I thanked her, paid for the certified copies, and walked outside carrying far more questions than answers. Most property disputes I had encountered during my career involved overlapping surveys, misplaced fences, or unclear boundary descriptions. This situation was entirely different. Hundreds of families appeared to believe they owned homes inside a neighborhood that existed physically, financially, and socially, yet the public land records told a completely different story. Instead of driving back to the motel, I stopped at the county planning department. The receptionist directed me to an older planner named Michael Reeves, who had worked there for more than 25 years. When I explained why I was visiting, he listened without interrupting before opening several historical planning maps stored in large flat drawers. We spread them across a conference table, comparing development plans from different decades. One preliminary proposal caught both of our attention. Nearly 18 years earlier, a private development company had submitted conceptual drawings for a residential community covering part of the Mercer Valley. The proposal included streets, parks, walking trails, and several hundred homes. Across the first page, however, a large red stamp read, "Preliminary submission only, not final approval." Michael traced the stamp with one finger. "A preliminary concept is not permission to build," he said. "Final approvals require additional filings, recorded plats, and several legal steps before lots can be sold." We searched the department archives for those later approvals. None appeared. Michael frowned, clearly puzzled. "Either the file is incomplete," he said, "or something happened before the process was ever finished." That possibility stayed with me during the drive back toward the valley. Rather than entering through the main gate again, I parked along a public overlook where I could quietly observe the community from a distance. Landscaping crews maintained flower beds near the clubhouse. Parents walked children home from a neighborhood playground. Delivery trucks entered without delay, and residents greeted one another with the comfortable familiarity that develops only after years of living together. Nothing about the scene suggested deception. If anything, the people living there looked completely convinced they belonged. That realization changed my perspective. My concern was no longer directed toward the families inside Silver Ridge Estates. It was directed toward whoever had convinced them that everything had been handled properly. As the afternoon sun settled behind the western ridge, I noticed Victoria leaving the clubhouse carrying a stack of folders. She stopped several times to chat with residents, smiling confidently and answering questions as though she had complete authority over every corner of the valley. Watching from across the overlook, I realized something important. She did not behave like someone hiding a secret. She behaved like someone who genuinely believed the story she had been telling for years. Whether that belief was accurate or not was another question entirely, and I had no intention of answering it through arguments in the middle of a neighborhood street. I was going to answer it the same way every serious land question should be answered, one document at a time. The following morning, I met with a real estate attorney named Laura Bennett, someone I had worked with professionally on complicated land transactions years earlier. She listened without interrupting while I organized the certified records, historical surveys, planning department copies, and estate documents across her conference table. Every few minutes, she made another handwritten note, occasionally comparing dates from different files before moving to the next document. When she finally leaned back in her chair, her expression was thoughtful rather than excited. "You have a very strong ownership record," she said. "What you do not have yet is an explanation for why an entire residential community exists on land that still appears to belong to your family." She explained that unusual situations sometimes developed when proposed subdivisions stalled, ownership disputes remained unresolved, or developers failed to complete every legal requirement before construction continued under incorrect assumptions. None of those possibilities automatically determined what had happened here, but each deserved careful investigation before anyone reached conclusions. Her advice was simple. Do not confront residents. Do not make public accusations. Gather every available record first. That matched exactly how I preferred to handle complicated property questions. Over the next several days, we submitted formal requests for archived planning files, historical tax records, title materials, and development agreements connected to Silver Ridge Estates. While those requests moved through government offices, I drove past the valley only occasionally, never entering the neighborhood itself. From public roads, I watched ordinary families going about ordinary lives. Children waited for school buses. Contractors repaired fences. Neighbors talked while collecting their mail. Nothing suggested that the people living there believed they were doing anything improper. Late Friday afternoon, my phone rang. The caller identified herself as the community manager for Silver Ridge Estates and politely informed me that the Homeowners Association board wished to discuss what she described as my recent visits near the neighborhood entrance. We agreed to meet the following Monday inside the clubhouse conference room. When I arrived, Victoria Langford was already seated at the head of a polished wooden table. Her colorful designer jacket, oversized jewelry, and perfectly arranged folders gave the meeting an unmistakably formal appearance. Several board members sat quietly beside her, each with copies of what appeared to be community governing documents. Victoria welcomed me with practiced professionalism before sliding a neatly printed packet across the table. "We understand that you believe you have an ownership interest somewhere near the community," she began. "However, Silver Ridge Estates has operated successfully for many years. Residents purchased their homes in good faith, property taxes have been paid, services have been maintained, and the association has responsibly governed the neighborhood throughout that time." I thanked her for meeting with me and explained that I was still gathering historical records before reaching any conclusions. I intentionally avoided making dramatic statements because the facts were still developing. Victoria nodded politely, although the confidence in her smile never changed. She opened another folder containing promotional maps, neighborhood maintenance reports, landscaping contracts, and photographs from community events dating back more than a decade. Everything demonstrated that the association had functioned continuously for years. What none of the materials demonstrated was the legal transfer of ownership from the Mercer family. When I politely asked whether the board possessed the recorded subdivision documents or deed history creating the residential lots, Victoria answered without hesitation. "Our legal affairs have always been handled appropriately," she replied. "I am certain every necessary document exists somewhere within the original development files." The wording caught my attention immediately. She had not said she had seen the documents. She had not produced copies. She simply believed they existed. That distinction mattered. After the meeting concluded, Laura and I compared notes. Neither of us believed Victoria was intentionally misleading anyone. Instead, she appeared to have inherited assumptions that had been repeated so often they were accepted as unquestionable fact. A few days later, another response arrived from the county archives. Inside the envelope was a decades-old letter addressed to the original developer. The county had rejected the final subdivision filing because several required ownership certifications had never been completed. At the bottom of the page, a handwritten note indicated that no corrected filing had ever been received. Laura looked at the letter for several quiet seconds before placing it beside the uninterrupted chain of title. "If additional records confirm this," she said, "then the entire history of Silver Ridge Estates may have been built on an approval process that was never legally finished." The letter from the county archives changed the direction of the entire investigation because, for the first time, we were no longer dealing with assumptions. We were looking at an official government record explaining that the original subdivision process had stopped before the final legal requirements were completed. Laura immediately requested every remaining archive connected to the proposed development, while I continued tracing the ownership history one document at a time. During the following week, we assembled a timeline stretching back nearly 20 years. The original developer had acquired construction rights for certain improvements, submitted preliminary plans, and received permission to begin limited infrastructure work while additional legal documents were still pending. Roads had been graded. Utility corridors had been planned. Environmental reviews had moved forward. Then the paper trail became strangely quiet. The company that initiated the project experienced financial problems before the subdivision process reached its final stage. Several corporate filings showed ownership changes inside the development company itself, but none transferred ownership of the Mercer Valley. The land remained exactly where it had always been in the county records, under the Mercer Family Trust. Somehow construction continued anyway. Laura believed the most likely explanation was that later investors, contractors, lenders, and eventually homebuyers relied on previous assumptions instead of independently verifying every recorded document. That possibility did not automatically determine anyone's legal rights, but it explained how an entire community could sincerely believe everything had been handled correctly. The more we investigated, the less interested I became in blaming individual residents. Most families had probably purchased their homes believing licensed professionals had completed every required step years before they ever arrived. If mistakes had been made, they appeared to reach much further back than the current homeowners. A few days later, another certified package arrived from the title research company Laura had hired. Inside were certified copies of every recorded deed connected to the valley since the 1940s. We spread them across her conference table in chronological order. Every transfer was accounted for. Every signature matched probate records. Every legal description remained consistent. There was no missing conveyance, no forgotten sale, no hidden agreement. The Mercer family had never signed away ownership of the valley itself. Laura slowly closed the final folder before looking directly at me. "This is one of the cleanest ownership chains I have ever reviewed," she said. "If another recorded transfer exists, it is not showing up in any county, state, or title archive we have searched." Even with that information, she cautioned against reaching dramatic conclusions. Property law involved many layers beyond recorded ownership, and every affected party deserved an opportunity to present whatever documents they believed supported their position. I agreed completely. Winning an argument had never been my objective. Understanding the truth was. Later that afternoon, I drove past Silver Ridge Estates once again. Autumn had begun settling into the valley, and the mountains surrounding the community glowed beneath the late afternoon sun. Residents were decorating front porches, children were riding bicycles through quiet streets, and volunteers were preparing flower beds outside the clubhouse for the coming season. It looked like every successful neighborhood I had ever seen. As I watched from the public overlook, I noticed Victoria directing several landscaping crews with the same confident authority she displayed during our meeting. She greeted neighbors warmly, reviewed maintenance schedules, and answered questions about upcoming community events. Nothing about her behavior suggested someone secretly orchestrating wrongdoing. Instead, she appeared completely convinced that the association stood on solid legal ground. That observation reinforced something I had been thinking for days. Confidence was not evidence. Neither was tradition. A practice repeated for 20 years did not automatically become legally correct simply because everyone had grown accustomed to it. Before leaving, my telephone rang again. It was Laura. Her voice carried a level of excitement I had not heard before. One of the archived engineering files contained an overlooked memorandum written shortly after the county rejected the final subdivision filing. According to the engineer's notes, all future construction was supposed to pause until ownership certifications were resolved. Laura paused for a moment before adding the sentence that stayed with me the entire drive back to town. Caleb, if those instructions were never completed, then every important decision made afterward may have rested on a misunderstanding that nobody bothered to question for nearly 2 decades. Laura spent the next several days assembling every certified record into a single chronological case file, and the difference between assumptions and documented facts became clearer with every page we added. The Mercer family ownership records formed one uninterrupted chain stretching back nearly 80 years. The planning department files documented a proposed residential development that advanced through early review stages but stopped before final subdivision approval. The engineering memorandum instructed that additional construction should not proceed until unresolved ownership certifications had been completed. Yet despite those gaps, the valley had gradually transformed into a thriving neighborhood over the following 2 decades. None of those facts alone answered every legal question, but together they created a picture that demanded careful review instead of speculation. Laura recommended that our first formal step should not be a lawsuit or a public announcement. Instead, we prepared a detailed notice requesting that the Silver Ridge Homeowners Association produce every document it believed established its legal authority over the land. The request was respectful, specific, and supported by certified references rather than accusations. A week later we met again inside the clubhouse conference room. Victoria Langford entered wearing another brightly colored designer blazer, oversized jewelry, and the same calm confidence she had displayed during every previous conversation. Several board members accompanied her along with the association's attorney, Richard Collins, who greeted us professionally before everyone exchanged copies of the relevant documents. Laura presented the certified ownership history, the county archive records, and the planning department correspondence without dramatic commentary. Richard reviewed each page carefully, making handwritten notes as the meeting continued. Victoria remained composed, occasionally reminding the room that the community had existed peacefully for many years and that hundreds of families had relied upon the association's governance. No one disagreed with that observation. The discussion was never about whether residents had built a functioning neighborhood. It was about understanding the legal foundation beneath it. When Laura finished explaining the county records, Richard requested a short recess so he could privately review several older association files that had recently been retrieved from off-site storage. Nearly 40 minutes passed before he returned carrying 3 large binders. Together we examined recorded covenants, architectural guidelines, maintenance agreements, insurance policies, and meeting minutes dating back many years. The files documented how the community operated on a daily basis, but something continued to stand out. Whenever ownership of the underlying valley was mentioned, the documents referenced earlier development materials rather than a recorded transfer from the Mercer family. Richard quietly acknowledged that he would need additional time to verify whether earlier title documents existed outside the association archives. Victoria seemed genuinely surprised by that statement. She looked toward the binders before explaining that every previous board had assured residents all legal matters had been completed long before she became president. Her confidence did not disappear, but for the first time uncertainty appeared behind it. After the meeting concluded, Laura and I agreed not to interpret that uncertainty as wrongdoing. Organizations often inherit assumptions from previous leadership without independently verifying decades-old records. The following week, Richard contacted Laura and confirmed that his own title review had reached many of the same conclusions. He had located no recorded deed transferring ownership of the valley from the Mercer family. He emphasized that numerous legal issues still required careful analysis because the situation affected many homeowners acting in good faith, but he also acknowledged that the ownership history deserved judicial clarification. That conversation marked a significant turning point. Until then, nearly every discussion had centered on competing beliefs. Now both legal teams agreed that the historical record contained substantial unanswered questions requiring formal resolution. Laura prepared a petition asking the court to determine the respective legal rights of all interested parties based upon the complete documentary record rather than decades of assumption. We deliberately avoided inflammatory language because the goal was accuracy, not headlines. News of the filing spread quickly throughout Silver Ridge Estates. Some residents expressed confusion. Others asked thoughtful questions about the history of the development. Several admitted they had never seen the original property records before purchasing their homes. Through all of it, Victoria continued attending board meetings, reassuring residents that the association would cooperate fully with the legal process while encouraging everyone to remain calm until the evidence could be reviewed by the court. Watching those events unfold, I realized the case had quietly evolved into something much larger than a dispute over acreage. It had become an effort to uncover how an entire community had come to rely upon a version of history that no surviving document had yet been able to fully support. Several weeks passed before the court scheduled the first comprehensive hearing, giving every interested party time to gather historical records, expert opinions, and certified documents. By then, the case had attracted quiet attention throughout the county, not because anyone expected dramatic courtroom moments, but because experienced professionals had rarely seen a property history quite like this one. On the morning of the hearing, I arrived early with Laura Bennett, carrying the same leather binder that had slowly grown thicker as every verified document found its place inside. Across the courtroom, Victoria Langford sat beside Richard Collins wearing another bright designer blazer accented by oversized jewelry that reflected the overhead lights whenever she adjusted her notes. She still carried herself with confidence, greeting familiar residents with reassuring smiles before taking her seat. Looking around the room, I recognized many of the homeowners I had quietly observed from public roads over the previous month. They did not appear angry or defensive. Most simply looked concerned and eager to understand how two completely different versions of the property's history could exist at the same time. When the proceedings began, the court focused first on the documentary record rather than opinions. Certified title histories were introduced. County tax records were reviewed. Historical survey maps were compared with current parcel information displayed on large monitors, so every participant could follow the discussion. Planning Department employees explained the distinction between preliminary development approval and final recorded subdivision filings. The county recorder testified that no recorded deed transferring ownership of the original Mercer Valley had been located despite extensive searches through archived records. None of those presentations contained dramatic accusations. They simply established what the official files did and did not show. Richard then presented the association's evidence with equal professionalism. The governing documents demonstrated years of organized management, maintenance contracts, homeowner elections, insurance coverage, utility coordination, and community improvements. Hundreds of families had purchased homes believing the neighborhood had been properly established. Those facts were never disputed. The question before the court was not whether the community had functioned successfully. It was whether the legal foundation supporting that community had ever been completed according to the required property procedures. During a recess, several residents approached both legal teams with thoughtful questions. Some expressed surprise after learning that many historical documents they assumed existed had never actually been recorded. Others admitted they had never considered researching events that occurred decades before purchasing their homes. Their reactions reinforced something I had believed from the beginning. Most people had acted in good faith using the information available to them. As the hearing resumed, Laura introduced one final group of exhibits that had recently been obtained from the state archives. Among them was correspondence exchanged between the original developer, county officials, and financial lenders shortly before construction expanded throughout the valley. The letters consistently referenced unresolved ownership certifications that needed to be completed before final recording could occur. More importantly, none of the later files documented that those certifications were ever resolved. Richard carefully reviewed each exhibit before acknowledging that his own independent investigation had uncovered no contradictory records. Victoria listened quietly as the discussion unfolded. For the first time since I had met her at the entrance to Silver Ridge Estates, she appeared less focused on defending past assumptions and more interested in understanding how those assumptions had formed. The court concluded the hearing by explaining that additional legal analysis would be required before determining the appropriate remedy, because any decision would affect numerous homeowners who had relied upon long-standing representations. Even so, The judge noted that the documentary evidence regarding ownership and recording history appeared remarkably consistent across multiple independent sources. Outside the courthouse, reporters gathered near the sidewalk hoping for dramatic statements. Neither legal team offered any. Laura simply explained that the matter remained before the court and deserved careful consideration based upon verified records rather than speculation. Richard agreed, emphasizing that cooperation would continue while the remaining legal questions were resolved. As I drove away that afternoon, I thought back to the first moment I had rounded the mountain road and seen the neighborhood standing inside the valley I had inherited. At the time, the situation had seemed almost impossible to understand. Now the pieces finally fit together. Years of assumptions, incomplete filings, changing leadership, and unquestioned paperwork had gradually created a version of history that everyone accepted because no one had ever assembled every original record in one place. The court now possessed that complete history, and whatever decision came next would be based not on confidence, tradition, or repetition, but on the documents that had quietly preserved the truth all along. Nearly a month passed before the court issued its written ruling, and during that time the atmosphere inside Silver Ridge Estates changed in ways I never expected. The uncertainty that had once fueled quiet speculation gradually gave way to careful conversations among neighbors who simply wanted to understand what would happen next. Instead of debating rumors, many residents began requesting copies of the public filings for themselves. Some attended county record sessions, while others asked questions during community meetings that had never been asked before. The focus slowly shifted away from defending assumptions and toward understanding documented history. When the court's decision finally arrived, Laura called before sunrise. Her voice remained calm, but I could hear the satisfaction that comes only after months of careful preparation. The ruling confirmed that the Mercer family ownership records represented the legally recognized chain of title, and that the historical subdivision process had never reached final recorded completion as required by the governing procedures in effect at the time. At the same time, the court recognized that hundreds of homeowners had purchased their properties in good faith, relying upon information they reasonably believed to be accurate. Rather than treating the situation as a simple dispute between winners and losers, the decision established a structured legal process allowing all affected interests to be addressed through the proper channels under court supervision. Laura explained that the next stage would involve implementing the court's orders in an organized manner with county oversight, so that every action remained transparent and legally documented. Several days later, I returned to the overlook where I had first watched the valley from a distance. Below me, county survey crews began placing temporary markers along existing boundaries while administrative staff coordinated appointments with homeowners, title professionals, and community representatives. Sheriff's deputies were present only to maintain orderly public access during scheduled activities, and the atmosphere remained calm throughout the day. There were no dramatic confrontations. Most residents simply watched with understandable curiosity as officials carried out responsibilities that had been carefully planned weeks in advance. Victoria arrived shortly after the county teams entered the neighborhood. She stepped from her vehicle wearing another colorful designer blazer with oversized jewelry that reflected the morning sunlight exactly as it had the day we first met. Yet something about her expression had changed. The absolute certainty she once carried had been replaced by thoughtful restraint. She spent much of the morning speaking quietly with residents, encouraging everyone to cooperate with the administrative process, while assuring them that the legal questions affecting individual properties would continue to be handled through established procedures. Later that afternoon, she approached Laura and me outside the clubhouse. For several moments, none of us spoke. Finally, Victoria looked toward the valley before saying something I had not expected to hear. She admitted that every board she had served alongside had inherited the same understanding of the community's history and that she had never imagined the original ownership records could tell such a different story. She explained that she had genuinely believed she was protecting the neighborhood by enforcing the association's rules because that was the responsibility passed down to her. I appreciated her honesty because it confirmed what the evidence had gradually suggested throughout the case. Confidence alone had never created the problem. Unquestioned assumptions had. During the following weeks, court-appointed professionals worked with county officials, legal representatives, and affected property owners to begin resolving the complicated administrative issues left behind by decades of incomplete documentation. Every meeting emphasized cooperation, transparency, and accurate record-keeping. Residents who had once viewed me as a stranger slowly introduced themselves during public information sessions. Many shared stories about raising families in the valley, planting trees, volunteering at community events, and building friendships that had nothing to do with legal filings recorded years before they arrived. Listening to them reinforced my determination to approach every remaining decision with fairness rather than resentment. One evening, as the last county vehicles departed after another productive day of administrative work, I stood near the entrance monument where Victoria had first questioned why I was parked on what she believed was private community property. The stone sign still welcomed visitors to Silver Ridge Estates, but now everyone understood that the history beneath those words was far more complicated than anyone had imagined. The legal questions that had remained hidden for nearly 2 decades were finally being answered through documents instead of assumptions, and for the first time since inheriting the valley, I could see a realistic path toward resolving the future without erasing the lives that had already been built there. Over the following several months, the valley slowly entered a new chapter that looked very different from the uncertainty that had surrounded it when I first arrived. Court-supervised administrative work continued at a steady pace, allowing every affected property owner to receive clear information about the available legal pathways for resolving their individual situations. Engineers updated surveys using modern equipment, title professionals reviewed historical records alongside current filings, and county officials maintained regular public meetings so that residents understood every step instead of relying on rumors. Watching that process unfold reminded me that complicated problems rarely disappear overnight, but they can be solved when everyone agrees that facts matter more than assumptions. My own role changed as well. Instead of spending every day gathering evidence, I focused on protecting the valley while working with professionals who specialized in land management, conservation, and long-term planning. Large portions of the original acreage remained untouched forests, streams, and open meadows that had been preserved through decades of family ownership without anyone realizing it. Rather than rushing to develop more land, I chose to keep those natural areas protected for future generations while exploring practical solutions that respected both the legal reality and the lives people had built there. One afternoon, I met Victoria near the old clubhouse for what would become our final conversation about the case. She wore another colorful designer blazer, although this time the confidence that had once dominated every discussion had been replaced by something much quieter. She admitted that reviewing the original records had forced her to reconsider many assumptions she had accepted without question after joining the association years earlier. She told me she wished someone had asked difficult questions much sooner because the answers might have prevented years of misunderstanding. I appreciated her honesty because accepting uncomfortable facts often requires more courage than defending familiar beliefs. Before leaving, she extended her hand and wished me success with the future of the valley. I shook her hand and sincerely wished her the same. There was no celebration, no dramatic victory, and no sense that one side had defeated the other. Instead, there was something far more valuable. There was clarity. Looking back now, I often think about how easily appearances can shape our understanding of reality. When I first drove through the entrance to Silver Ridge Estates, everything looked permanent. Beautiful homes lined the streets. Families enjoyed neighborhood parks. Community events filled the calendar. It would have been easy to assume that every document behind those scenes had been completed exactly as people believed. Yet one careful review of the public record revealed a very different story. That experience reinforced a lesson my work had already taught me many times. Trust is important, but verification matters just as much. Whether you are buying land, signing a contract, or making decisions that affect other people, taking the time to understand the facts can prevent years of confusion later. Today, the valley remains one of the most remarkable places I have ever seen. The mountains still surround the open meadows. The streams continue flowing through the same channels that existed long before any neighborhood appeared. Families still gather for holidays, children still ride bicycles through quiet streets, and neighbors still wave to one another during evening walks. The difference is that the future is now being built on accurate records instead of inherited assumptions. In the end, The greatest inheritance I received was not 2,500 acres of land. It was the responsibility to uncover the truth, treat people fairly, and leave the valley in better condition than I found it. I would rather be remembered for doing that than for winning any legal dispute. Now I would genuinely like to hear your thoughts. If you discovered that an entire community had unknowingly been built around an incomplete legal history, how do you think the situation should be resolved fairly for everyone involved? Share your opinion in the comments because I always enjoy reading different perspectives on stories like this. And if you enjoy thoughtful stories about property disputes, legal challenges, and ordinary people solving extraordinary problems through patience, evidence, and common sense, consider subscribing so you do not miss the next story. Thank you for spending your time with me, and I will see you again in the next one.